Blinking red, does that mean anything?
Oh, actually, legal court's
He's
last.
reporting on 4 different.
Okay.
I'll just let it sit.
Call this meeting back into session. For you attendees, I'm also an auctioneer. I like gavels. Now, Julie Crop.
No, we got the.
I thought you had the Wayne thing.
We got the Wayne thing.
Oh, yes,
That's the
I
Wayne Pugh.
forgot. Wayne Pugh, I'm turning it over to you, Commissioner Flitcroft.
Mr. Chairman, my recollection, I don't think it has to be a motion, is when we meet in Nashville there, I'd like to have staff present a letter that we can all sign recognizing Wayne Pugh for all of his hard work and diligent service and guidance he's given us. I don't know how we're going to do it without him, but he's been...
You've heard what Commissioner Flitcroft has, you put that in the form of a motion, didn't you?
That is a motion.
I will second that. I think we certainly need to do something for Mr. Pugh.
Mr. DeShar will second that, and this is one of those motions that there cannot be any opposition to. He has done a wonderful job. Does anybody know where's he going?
He's already there. He's at the Tennessee Board of Regents. He's, I believe, the work he's doing involves contracts, and it's not a managerial role, which I think he was excited about, and I think it was a good opportunity for him.
I could make a comment right now, but I'm gonna keep my mouth shut.
Then when did he
Would it be
go to
about
Washington
lawyers?
State, do you know? I remember him in the early 90s.
He worked there for a while, and then he said, he indicated that he left for a little bit, and then for the last 11 years, he's been consecutively with the department, but I think he worked there prior to that too, and left for a short period of time in
Because
between.
I remember him, yeah.
We went to the auto auction.
Yeah, I think that was what was in between.
He was there when I was on the appraisal commission.
He was there.
The last 11, I think he said the last 11 years were consecutive, but there was a brief
Yeah,
interim.
he was there.
Well, he's still a state employee.
He is. He finished with us on a
Higher
Friday.
grounds.
Yeah.
Talk up or
He started working.
talk up or talk closer. Any other discussion on the motion? Here none, all in favor say aye. Aye. Opposed, no. Motion carries. Next, we have
Now we have to.
Julie Croston, our
last-
attorney with our legal report.
Last month, we had talked about, at the end of our formal hearings, the possibility of Robin and I, as well as Laura and Wayne actually sat in on the meeting with Judge Stovall and Robin, I can't remember the name of the other administrative law judge. His name is Collier. Collier.
Robert Collier, I believe.
We had a meeting regarding just tossing around ideas for cases to that could we could use ALJs for in the future, and just kind of what we came up with in that meeting. And we were just reporting back on this to see what y'all's thoughts were. I think there was a motion last month about ALJs handling cases involving unlicensed activity, and the thought we had as far as some other possible broadly topicked items were things that are just black and white issues, where when it kind of relates strictly to something it's either there or it's not. For example, we've had a couple agreed citations that have come up as complaints for failing to take administrative measures in the right amount of time to retire a license or affiliate with another broker. Sometimes that hasn't been settled as a citation, and that's the only issue. Something like that might be easily addressed by administrative law judge, because either you did it during the time period or you didn't. Another issue is sometimes it comes down to just a pure failure to respond. That's all that, you know. We had one a couple months ago where the commission didn't see a violation except for failing to respond. If for some reason somebody doesn't pay a consent order on something like that, that's something that might be suitable for an ALJ. It's just black and white, easy, you know, determination. It doesn't come down to a standard of care. Those were just some examples we came up with. I just thought I'd let you know. I mean, Robin, do you have anything to add to that? It was a pretty brief meeting, and it really just came down to the issue of black and white cases such as those going to.
These are the cases that, after discussion with the judge, who also thought it might be appropriate for just the judge to hear it, they aren't cases of revocation or suspension of licenses. There's strictly civil penalties for the violations, the small sections, failure to respond, failure to affiliate, Those were, and
And unlicensed.
and unlicensed activity.
Mhm.
And that it would be, could be easier and less painful for this commission to have an ALJ hear it alone. You don't have to do any of that. Right now, you had a motion from, a motion that was accepted from last month that it was failure to respond. Was that not the one we had last month?
Oh, the one that we had?
Yeah, what was the,
It was Austin's motion.
It was for unlicensed activity. Austin's motion was for
Austin
unlicensed
activity?
activity.
Okay. So that is something you've already agreed. You also have agreed in the past to let errors and omissions insurance be heard by an ALJ alone. It really is up to you all to make that decision. It just means that if you did, we might get some more heard, and you might not be stuck hearing cases that,
where people don't show up.
Well,
Yeah.
it would have been,
Or-
those would have
Well,
covered
the
the two last month. The
Well,
one in the afternoon was a failure to take administrative measures. That
people cannot show up anyway, like in defaults. I mean, you're still going to be stuck with that if it's before you, and so would the admin law judge, and I can't tell that beforehand, so that won't be it. From failing to show up, that won't be one of the ones. I can't do that up front.
You'll still give us a list of what the administrative judge has said?
Well, that's what he said. He had suggested those. Is that not right? Is that your memory also, Eve? Oh, you mean as far as what happened in hearing? Oh, let me explain that to you too as well.
Yeah, how does that?
So you understand that no matter what the ALJ does, that initial order is just that, an initial order, and it is then presented to the commission as a whole, and you all can agree or disagree with the
Oh,
decision
okay.
of the judge. Okay,
I like
so
that.
it's not the judge going over you at all, because if something came down and you in review think that's not right, then no, you don't have to approve that.
Now, before all of this goes to the administrative judge, any of it gonna come before this commission or to the chairman?
All cases come before you initially in an anonymous basis as in the purpose of comparing to, for instance, a probable cause hearing. And this is the result of it. And what she was talking about citations, what she was really talking about consent orders that were sent out that weren't addressed, and some citations.
Some of them start as citations and come up. They'll still all be presented as part of my legal report.
Right.
It's just that when, for example, you all authorize a consent order and it's just for failing to respond, for example, and I send out that consent order that you all have heard and authorized, if they don't respond and satisfy that in the 30-day period and it goes over to Robin, that would then be one that would be put in line for litigation before an ALJ. You would still hear it at the probable cause hearing, and that's when you all,
Mr. Chairman,
Commissioner Alexander.
I like the concept as long as the commission has control of it.
You always have control.
Let me justify this on open mic. There's 9 commissioners. You were appointed by the governor to protect the public. I'm not saying that an OJ or judge or whatever it is would not protect the public. My point is the first thing you know, you're going to be farming this part out, the next part out, and the next thing you've done, you've farmed this whole commission out to somebody else, and you don't need one. And I'm opposed to that in open mic. I'm not opposed to the concept, but I'm opposed to the fact that you give up, and that's my reason for my question is as long as we've got hands-on, then that's fine. But this thing of suddenly everybody decides that, well, we don't need the commissioners to handle that or the other. And I'm not, you see the point I'm making is that then you lose your autonomy. Is that the big word you say?
We say lots of big words.
That's my, I want to speak to that point. Now, the other commissioners may have a different feeling, but I pride myself for being on this commission. And if you're going to be on it, then you ought to represent the public.
I support you entirely. The reason this came up is because you guys have had to sit through some pretty mundane cases, and I know, but it's not. It may not be cost-effective for you, but more importantly, we may be able to get some of these through quicker. Those are usually, I mean, I try to do my cases oldest first or most egregious first, as per a previous discussion from you all about bad cases going to the front of the line, but we also don't want to leave someone who hasn't affiliated out there forever, and it may be a year before I get to a hearing, and that was one of the reasons we were just suggesting that maybe some easy enough cases that could be addressed. And yes, Commissioner Alexander, you hear the reason for the hearing before it gets there, because Julie presents it anonymously in the legal report. And after an ALJ issues its order, you also get a review of that and have an opportunity to agree or disagree. So the power is not taken from you, it's just sort of, you get help.
I just made my point, that's all I wanted.
But I wanted to reassure you of that.
I have just a question. What if on the commission, what if there's an ALJ's decision made, and then it comes to the commission to, I guess, give the final approval on that? What if they don't agree with that decision? Does the person, do they go through another formal hearing? What's the process for that?
I'm not, actually not entirely, I didn't bring my book with me, okay, the ALJ book, and I'm not entirely sure. I don't know if it comes then before the commission itself, or if indeed it's just appealed by the commission to the chancellor. I don't know. I can check on that and address that tomorrow. It's in the ALJ, or administrative law
Okay, so,
book.
all right.
Yeah,
I
it
just
is
wondered if
addressed.
there'd be another formal hearing, or if it.
Well, and I don't
Yeah,
really.
okay.
Yeah. And the reason I don't know for sure, because it's not come up to my knowledge that I would have seen, so.
Right, no, yeah, I just was curious what would happen.
But I do have it, I do have my rule book with me.
I think that's a real important question. Thank you, Eve. I think it's something that matters to all the commissioners.
Mr. Chairman, I'm probably the culprit that brought this before the commission. I asked Ms. Maxwell to include it as an item and mentioned it to you as well. I'm thinking of Gary Cunningham's rule, and Gary, of course, was the Sterling Commissioner back several years ago, who said that we needed to worry a lot more about murderers than we did about jaywalkers. And unlicensed activity is certainly jaywalking, because, you know, it's a problem, but it's a problem we don't really have a solution for anyway. And spending 4 hours on a hearing in Nashville on a person that didn't have a license and may or may not have been advertising, wasn't all that clear whether he was or not. And I and John Grease knew him anyway, so we recused ourselves. It appears that staff has identified failing to take administrative measures, failing to respond, failing to pay as agreed as 3 items. Initially, when I considered this thing, I thought, well, what we need to do is just to run all the legal proceedings that we're going to take a formal adjudication before this commission, run by you. But then Robin has pointed out, I think she's right, that if we did that and you decided that we're going to hear it, that you'd have to recuse yourself. That seems onerous there. So I make a motion that we take the murderers first and jaywalkers second, and that any complaint that requires formal adjudication by this commission be first assigned to the administrative law judge if it involves failure to take administrative matters, a failure to respond, or a failure to pay as already agreed.
It's not palliative, sorry, excuse me for interrupting you in your motion. It's a citation that was issued that was not paid, not failure to pay to something was agreed.
It's just failing to respond and then failing to take administrative measures.
I stand corrected, and
I'm
that's
sorry if I wasn't clear.
That's the motion.
I'm not gonna ask you to repeat it. But you've heard the motion. Do I hear a second?
I'm going to second the motion.
I think the gist is this motion, we're gonna get the bad boys first and the bad women first, bad boys and bad women, we're going to take the most egregious ones first, and then we'll get to the rest of them whenever.
Sure.
Discussion, Mr. Norman.
Just one question of, I guess, Robin, since she's litigation. If I look at the consent order log, there are like 29 cases that have moved to litigation going back to January of 2012. Am I looking at it correctly?
Is that right, Julie? There are 29? I don't think I have 29 right now.
Some of them have probably been tried. This is just my tracking. This is where I keep track of my consent orders, so I guess. Yes, these are all of the ones that have been moved to litigation. Some of them at this point have been tried and everything. This is my tracking mechanism for the
Okay,
consent
so
orders and getting
something
them
less
to
than
Robin.
29?
Yes, are currently in litigation, yes.
And given that we meet monthly,
Right.
and that we normally see one case per meeting,
Right,
sometimes we try to see two,
right.
we're backed up from January of 2012 now?
No, my consent order log is, I guess I should. I update that for my tracking of what you all have authorized, what I've sent out, and making sure it gets moved over to litigation. I then, at that point, don't put on there what Robin has done with it. This is just my consent order log. It's keeping track of my consent orders, so.
Well, my point is that if we've got half the number of cases in the pipeline that's on here, and we're only disposing of one per month, we're never going to get caught up.
And that's right.
And that's, that's too long for someone to be waiting to have their case heard before this body. We need to do something to try to resolve that, whether it be moving it to an ALJ or something. And I'm just speaking, I guess, in favor of the ALJ, but we need to be trying to dispose of these that are already in the backlog and prevent it from getting any longer.
I think some of those, Commissioner Northern, some of those cases are ones that we're waiting on for civil suits outside of this commission to be settled before they go complete.
No,
Is that not part of those cases?
There are a couple of my little litigation monitoring consent orders on here.
But those aren't those are not in the litigation
No, they're not
status.
in litigation. These are, I mean, some of these have already been tried. I mean, I've got an unredacted version, so I can tell a little bit more. But some of these on this list have already gone through formal hearing. I just keep track of a running list. That's why it's all on there.
And just to clarify, and I don't think I really need to, but I do want you to understand this as well. This year, for instance, I think at least 3 times cases were continued, which is always going to happen, and it's always going to be granted. So yes, that puts us at another disadvantage. I mean, this is no different than any other commission. We're all in the same boat. Laura Betty has gotten for us 3 days a month of ALJs alone, and you all have always had an ALJ attached to your monthly meeting, so that helps quite a bit. But we have incredible number of cases that can't actually easily be heard in any one time period, and you are in better shape than many. I mean, I'm trying cases from 2009 in other departments. That's not unusual. But the problem is going to be, unlike court, when you go into court and you get a continuance, it's set the next time and that's it, end of the story as a general rule. We have to then set it for when there's a next available date period. And that could be months or the months and months before it happens. So some of the cases you see right now, Mr. Northern, are cases that were continued. But yes, we have a number of them that have to be heard. And I frankly don't want to try cases that have any kind of complex good issues before just an ALJ. That's me, because I'd rather have you all be making that determination. That's me as the litigator, because I know you know the laws. But when we are talking about something simple, like failing to respond or failing to take administrative measures, it just might be more efficient to have them heard before an ALJ. And that was the reason for those.
And unlicensed activity.
And unlicensed activity. some not all unlicensed activity, just the ones that I'm pretty sure are pretty black and white unlicensed activity. There, again, going to be some that I'm not going to be comfortable having before an ALJ on that either.
Commissioner Alexander.
I second the motion. I'm going to vote for the motion.
You call it.
But, no, I hadn't called for the question yet. I'm fixing to see if we can reach an agreement without me making another motion, that next month we have a list of those cases that you think that you will go before the judge, that you're going to sign to them, a list that you think that we look at and scrutinize and talk about next month. You understand what I'm saying? What they're going to refer?
That is the list. Those two right now are the list, those three, those types of cases. Not individual cases. I don't think I can bring individuals one for you before it, I don't think easily. But these are the types. That is the list that we came up with after meeting with Judge Stovall at his suggestion and Judge Collier. The three types are those cases where the sole issue is failure to respond it's actually failure to respond period, not even within the 10 days. Failure to respond, failure to take administrative measures. And
Failure to what?
Take administrative measures. That is failure to affiliate yourself with another firm, or failure to put yourself in retirement, or after you've been released from a broker. And then the third one is unlicensed activity.
Call for the question.
You heard the motion, you've heard the second, you've heard the discussion. Hearing none
Can
other.
you restate the motion for clarity purposes?
No. Commissioner Flitcroft might be able to.
Mr. Chairman, the Gary Cunningham rule, which was a motion at the time, said that we are going to prosecute murderers before we prosecute jaywalkers. And in that light, and in previous orders of this commission, I would move that certain matters which are, I'm going to say, mundane, which really don't need to have our attention, ought to be referred automatically to the ALJ, subject to our subsequent consideration and ratification or disapproval. And those three matters are, heretofore we've already assigned all the E&O, and by Mr. McMillan's motion and approval of the commission last meeting in Nashville, unlicensed activity, but there are three. One is failure to take administrative measures, and I think that is like failure to affiliate within the required period of time. Failure to respond, and especially if you don't respond, I mean, in my practice area, if you get sued and you don't show up and you don't file an answer, the judge is going to pretty much take care of it. And the third one, I can't really.
That was
citation.
It was tied into the other.
Tied into it, failure to respond to a citation, is that?
Those are the ones that are the failure to affiliate.
Failure to affiliate.
Yeah.
Thank you, Mr. Flitcroft. Question's been called. All in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Can't wait to see that in writing.
I'm sorry, what?
I said I can't wait to see that motion in writing.
Yeah.
Kelly will,
Looking forward to the minutes.
Kelly will have it in writing.
Who's got it?
She'll decipher what Commissioner Flitcroft said.
Which is pretty much letting an ALJ take care of the rest. They need to move along.
Yeah, good job. Parking tickets.
Yep.
Yeah, I like that better.
Next is the legislative update. On your iPads, you have a copy of Public Chapter number 84. That is the E&O bill that we were discussing earlier. It was signed by Governor Haslam on April 12th, 2013. So that was since our last meeting. I think it was up for his signature at our last meeting. It has been signed and assigned a Public Chapter number that allows for automatic suspension of a license for failing to maintain E&O insurance, and outlines a number of provisions for being able to correct that issue afterward. It also provides for eventual revocation if the person allows their E&O insurance to lapse for, I believe it's a year, for more than 1 year. The effective date on that is July 1st, 2013, and we're going to talk more with Chief Legal Counsel back in the office about how we need to apply that to this round of delinquent licensees, and we'll report back to you fully on that at the next. Can you not hear me? I'm sorry. I thought it was amplified. You can't hear me?
You need to just get closer so it's a
Okay.
little more clear.
All right. Well,
I'm not sure they can hear.
and then the second one is Senate Bill 942 involved, what, am I too loud now? Can you hear me? Senate Bill 942.
Is that on our iPad?
No, I printed this information because I cannot find a signed public act yet. I don't believe the governor has signed it at this point, so I did a little research on my own. And- I'm sorry?
He was talking to.
Oh.
SB 942?
SB 942 is the background check bill. It's the, it allows, basically, got it right here. We've talked about it in past meetings, but it's anyone that applies for licensure after the effective date of this, whenever this bill is passed, which I believe the effective date on it is January 1st, 2014, anybody that, that includes timeshare salespersons to submit fingerprints for the purpose of a background check. I believe the amendment, there were two amendments to it, and what I cannot access on the internet is which amendment finally went up. From the information I obtained, I believe it was the second one, which authorizes the issuance of electronic fingerprints as well. And it also would specify, I believe, if it's Amendment 2 that went up with it, that fingerprints are not required on renewal and for affiliates that are upgrading to brokers. It's just new applicants. Now, the most recent information that I got as of yesterday off of 10 Tracks is that it has been transmitted to the governor for action. However, I do not have a signed copy yet, but according to the tracking mechanism I have, it will be signed in the near future. I just don't have a copy of the public act yet. But based on the information I obtained online, all information indicates that this will be signed into law by the governor. So we will get, I'll have Ms. Maxwell transmit copies of that to you all as soon as it is signed. I just don't have a signed copy at this time, so.
Any of you that's talking about the public, about the fines of the E&O, it's been reduced, so you might ought to read that bill. The maximum fines and when the fines set in, from what there's been the policy of this commission, that bill changes the
fines?
yeah, it goes down. It's 500, 750 over a period of time, and active, if you read the bill.
I didn't see that. I wasn't looking.
Yeah, it was. I knew about it
Okay.
before it ever passed, but it wasn't gonna pass if it didn't get it done.
Yeah.
Okay.
Oh, I see it. I see.
It's under the legislative update tab.
Yeah.
Do you know?
Yeah, it's there.
Okay.
I see it.
I just want to, if
You just wanted
you're
to
out,
point out.
yeah, if you're out talking to somebody, and if you have to be making a speech to some association or something about the changes, and you need to read about the changes of, if you're quoting from what with the policy, the last policy wasn't what the new.
The fines are less.
Yes.
But the suspension is virtually immediate.
That's
I
what
mean,
we
So
need.
it's,
Yeah.
We're just trying to get them licensed, or I think wasn't interested in money that much.
Yeah.
it's compliance.
Are you ready for me to move on to legal report?
Yes.
Okay. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. I've got both of these listed on here, but I'm only representing one of them for just clarification.
Mr. Chairman, perhaps it'd be appropriate if I were to address the audience and describe the legal report in some detail.
That is an excellent idea, Commissioner Flitcroft, and you now
Quickly.
have the floor.
Ladies and gentlemen, you have had a pleasant and very relaxing 2 or 3 hours. I've noticed that most of you have stayed awake most of the time. But the legal report, you're going to find out, in the middle of it. The first part's all about vacation lodging, yeah, principally in Sevier County, and that's kind of boring. And the last part is about timeshares, and that's intervening. But the middle part is just exciting. It's better than watching Oprah Winfrey. Thank you, Mr. Chairman.
Thank you, Commissioner Flitcroft.
Now let's get Julie with her auctioneer's law.
You want me to use the auctioneer voice today? Okay. 2012025711 and 2012025721. Last month I presented this. It says complainant is the owner of a vacation home which is located near a number of homes which are being rented by an LLC, of which complainant states respondent 1 affiliate broker is a partner in contact for potential renters. Respondent 2 is respondent 1's principal broker. Sorry, I need to unclip my... Complainant states that respondent 1 and respondent 1's brother have rented all these homes listed on their website for years, packing in as many young kids as possible and hurting the property values. Complainant states that respondent 1 is running a property management company without a broker because complainant has contacted the firm at which respondent 1 was affiliated and was told the firm is not connected with respondent 1's LLC. Complainant states that respondent 1 is required to advertise the firm name and number where respondent 1 is affiliated when respondent 1 advertises vacation rentals for respondent 1's LLC. Respondent 1 submitted a response stating that Respondent 1 is licensed and in good standing with Respondent 1's association. Respondent 1 states that Respondent 1 and Respondent 1's brother are affiliated with several LLCs, one of which is the LLC referenced by complainant. Respondent 1 and Respondent 1's brother are also the developers of the development where the properties are located. Respondent 1 states that Respondent 1 is associated with a broker, and the LLC was a licensed vacation lodging service firm for which the firm license had lapsed without Respondent 1's awareness because the renewal information was mailed to an address other than the office address, and Respondent 1 was in the process of correcting this at the time that the complaint was submitted by reapplying for the vacation lodging firm license. With regard to the advertising complaint, Respondent 1 states that Respondent 1 was unaware that Respondent 1 needed to include Respondent 1's firm information for advertising for the vacation rentals. Respondent 2 submitted a response to the failure to supervise complaint stating that Respondent 2 knew that Respondent 1 owned some vacation properties with Respondent 1's brother that were leased on an overnight basis under a vacation lodging firm license, and those did not go through the firm. Respondent 2 states that Respondent 1 wanted to maintain a license for properties that Respondent 1 might want to list or sell, and in the past it had some properties listed with Respondent 2's firm, which were displayed on the firm website at the time with the firm name and phone number. With regard to the advertising complaint, Respondent 2 states that Respondent 2 made the determination that the Vacation Lodging Services LLC's website could be seen as confusing to the public without the firm information included along with Respondent 1's name, and made the decision ultimately after receiving this complaint to ask Respondent 1 to transfer Respondent 1's license to another firm. Respondent 2 states that upon receiving the complaint and verifying a possible problem, Respondent 2 took action and Respondent 1's license was amicably released to Trek. Complainant submitted a number of additional letters stating that Respondent 1 and Respondent 1's brother continue to operate what complainant calls a large-scale property management company without any involvement from the firm where Respondent 1's affiliate broker license is held. Complainant also included properties near complainant's home for which Respondent 1's LLC handles the vacation rentals. Complainant states that the renters are out of control, that renters trash the homes they are renting, and renters park too many cars in the roadway which blocks access. Complainant states the complainant is frustrated having spent a large amount of money on a home where they are out of control renters and an illegally managed property management company. Further, complainant states that Respondent 1 advertises vacation rentals in the development on a national vacation rentals website in which Respondent 1 calls himself the owner of the home. The website has a link to an email owner which emails Respondent 1. The national websites for vacation rentals state that they are used for both owner vacation rentals as well as privately owned properties offered through rental managers, which is what Respondent 1 appears to be doing. The website profile for one of the properties states that Respondent 1's a realtor in Tennessee, and at this point, Respondent 1 was released by Respondent 1's broker. Based on the materials provided by the complainant and accessed on Respondent 1's website, it appears that Respondent 1 is not operating a property management company, as complainant calls it, but is operating a vacation lodging service firm. As Respondent 1 stated, the vacation lodging service firm license had lapsed, but currently the LLC is actively licensed as a vacation lodging service firm, and Respondent 1 is its designated agent. Additionally, it would not appear that Respondent 1 would have to include a firm name and telephone number on advertisements for vacation rentals through the vacation lodging service firm. However, Respondent 1 was broker released on or about December 10th, 2012, and as of, I have here April 1st, 2013, because that's what I originally presented, but I checked it yesterday on the system, and he was still in broker release. Respondent 1 has not retired Respondent 1's affiliate broker license or affiliated with another firm. The recommendation at that time was have a consent order for Respondent 1 for $500 based on failure to complete administrative measures as required by Section 6213-312B, 14, and 16, and Rule 1262.02, subsection 2, plus attendance at one entire meeting of the Commission within 180 days of Respondent 1's execution of the consent order. And as to Respondent 2, dismiss. At the time, the Commission voted to accept the recommendation of legal counsel. I'm not representing it. I just did not send out the consent order yet because it was suggested to me that the above referenced authorized consent order for Respondent 1 should also specify a date range within which Respondent 1 must complete the required administrative measures for either change of affiliation or retirement of Respondent 1's license. It's recommended that in addition to the above referenced $500 amount and the meeting attendance requirement, that the consent order to Respondent 1 should require that Respondent 1 must complete the required administrative measures for either change of affiliation or retirement of Respondent 1's license within 10 days of the date of Respondent 1's execution of the consent order.
Move to accept council's recommendation.
Second.
I have a motion by Commissioner Northern, seconded by Commissioner Haynes, that we accept council's recommendation and do what she has recommended. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Number 3, 2012-022-891. Complainant is a resort management company in another state which alleges that Respondent, an unlicensed LLC, has performed a number of questionable timeshare transfers for individuals who were owners within several owner associations which were managed by Complainant. Specifically, Complainant states that several of the transfers include notary misconduct in notarizing signatures of people who were not in the state at the time that the documents were signed and notarized, and several transfers include new owner information which is incorrect. Complainant indicates that Respondent canceled some of these transfers, but Complainant states that this creates a cloud on the title. Respondent submitted a response along with recorded documents and explanations for each of the properties referenced by Complainant in the complaint. Respondent disputes the allegation that the new owner information was incorrect and states that all information provided to Complainant is the same contact information which was provided to Respondent. Respondent states that Respondent has recorded deeds transferring ownership back to the original owner for any transfers that were canceled before completion. Respondent also states that with regard to the notaries, Respondent had obtained limited durable power of attorney forms authorizing Respondent's owner to sign as agent for those owners who were not present in the state. The issue for Trex determination concerns only the issue of whether Respondent is engaged in unlicensed activity. Based on the information contained within the file, it appears that Respondent's sole involvement in the timeshare transfer process is to handle the title transfer paperwork, and while Complainant may have a private action against Respondent for any mistakes which may be in the deeds, the information in the file at this time does not appear to contain evidence of unlicensed activity on the part of Respondent, and therefore the recommendation is to close.
Any questions?
Motion to approve council's recommendation.
Second.
Commissioner DeShara makes a motion to accept council's recommendation and close, and seconded by Commissioner Haynes. Any discussion? Questions or comments? All in favor say aye. Aye. Opposed, no. Motion carries. Number 4 and 5.
Apologize for the length of this one, but I wanted to make it clear. 2012-025-801 and 2012-025-811. Complainants were the owners of a home as well as attempted home purchasers who filed a complaint against Respondent 1, an affiliate broker, based on their dealings with Respondent 1, with whom complainants entered into an exclusive right to sell listing agreement to list their home and exclusive buyer representation agreement regarding looking for a home to purchase. Track opened a complaint against Respondent 2, principal broker, who was Respondent 1's principal broker at the time of the subject incidents, for failure to supervise. Complainants state that when they met with Respondent 1 about selling their home, they made it clear that they first needed to sell their present home. Complainants viewed a home in which they were interested, which was bank-owned. I'll call it Home A, and complainants state that Respondent 1 told them that they could put a contingency contract on the home, and if complainant's home did not sell within a certain time period, complainants could get their earnest money back. Complainants went under contract on the home and submitted an earnest money check. The contract specified a closing date, which complainants state that Respondent 1 explained that the closing date meant that was when the contingency would expire. While under contract, despite Respondent 1's urging for complainants to get an appraisal on Home A, complainants state they resisted because they did not want to pay the money if their home did not sell. During the contract period, one of the complainants noticed that the home had been burglarized and called the listing agent after Respondent 1 could not be reached, and the police were called. Approximately 6 days before the specified closing date, complainants state that they told Respondent 1 that they would not be able to purchase Home A since their home had not been sold. At that point, complainants viewed a short sale home, Home B, with Respondent 1, and complainants asked Respondent 1 to submit an offer on Home B since the contract on Home A was about to expire. When complainants began asking for a return of their earnest money on Home A, complainants state that Respondent 1 instructed complainants to write a letter to the listing agent asking for the earnest money back due to the home being burglarized twice. A few days later, complainants contacted the listing broker directly for Home A and state that they told the broker that they had no problems with the break-in, but complainants had merely run out of time with selling their own home. At that time, complainants state that the listing broker informed them that he had no knowledge of a contingency contract. At that point, complainants state they had terminated Respondent 1 and learned from the listing broker on Home B that Respondent 1 had never submitted all of the required paperwork for the offer on the home. On that home, and that broker also did not realize complainants had another home for sale. The earnest money for Home A was dispersed to the seller at the agreement of complainants since the contract stated that the earnest money would be non-refundable 30 days after the binding agreement date, which had already passed before complainants began attempts to receive a return of the earnest money. Complainants attached documentation showing email correspondence from Home A's listing broker to Respondent 1 attempting to get information as to why the appraisal was not done and expressing concern over the closing occurring, to which it does not appear Respondent 1 replied, as well as email correspondence from Home B's listing broker requesting short sale paperwork to submit the offer, to which it also does not appear that Respondent 1 replied. Respondent 1 submitted a response stating that complainant's home was only on the market for 45 days before complainants withdrew it from the market. Respondent 1 seems to focus much of Respondent 1's response on Respondent 1's efforts to market and advertise selling complainant's home. Respondent 1 states that complainants wanted their home to sell before looking at homes, but then contacted Respondent 1 and asked to look at homes. Respondent 1 states that complainants made an offer on Home A, during which they asked questions about the process, short sales, lease purchases, and foreclosure processes, since Home A was a bank foreclosure. Respondent 1 states that it was explained to complainants that they placed a contingency on the offer for Home A, that the bank would not give it priority consideration, and it was conveyed verbally to the listing broker that the complainants had a home to sell. Respondent 1 states that Respondent 1 advised complainants to consider the listing and seller agent's stipulation to allow the complainants 30 days right of refusal on the contract, which they accepted, in reducing the earnest money from $1,500 to $1,000, 30 days of contingent of rescinding the contract offer. Respondent 1 states that complainants were advised by the lender to pay for the appraisal on the property, but complainants wanted to wait until an acceptable offer was received on complainant's home. Respondent 1 states that complainants and a family member then conducted their own home inspection, and complainants kept a journal of the report, which Respondent 1 states was never provided to Respondent 1. Respondent 1 states that complainants placed an offer on Home B, and Respondent 1 informed them of the contingency issue and asked them not to place it in the contract so the bank would show priority consideration to complainant's offer. Respondent 1 states that complainants refused to move forward on the sale of Home A due to the burglaries. Respondent 1 denies any wrongdoing. It does not appear that the requested additional short sale paperwork was submitted to Home B's listing broker by Respondent 1 despite the listing broker's request, and therefore the offer on Home B was never submitted. Based on contract copies for Home A and Home B, which were submitted, it appears that Respondent 1 did not include on either offer a termination date for acceptance by the seller, nor did Respondent 1 include a listing termination date on the exclusive right to sell listing agreement with complainants. Finally, when examining the offer to purchase Home B, it appears the signature dates have been altered, but the same signature of one of the complainants, which was on the offer for Home A, was used. According to complainants, Respondent 1 submitted the offer on Home B and sent a copy to complainants via email, which included one of complainant's signatures, but that complainant did not sign or give authorization to sign that complainant's name or change the dates, and parts of the contract for Home A, which included that complainant's signature, was used and dates were changed without complainant's consent. Finally, although Respondent 1 and complainants dispute the contingency clause issue, and it does not appear that there was a contingency clause in either of the signed offers from complainants, it does not appear that Respondent 1 adequately explained and complainants did not understand that this was not included, nor does it appear that Respondent 1 adequately explained to complainants so that complainants understood the 30-day non-refundable earnest money provision on Home A. The circumstances outlined in this paragraph indicate a violation by Respondent 1 for failure to include termination dates on multiple documents, as well as a failure to be loyal to the interests of Respondent 1's clients, and a failure to diligently exercise reasonable skill and care in providing services in the real estate transaction. Respondent 2 did not initially submit a response to the complaint. When legal counsel began reviewing the files, Respondent 2 was contacted by legal counsel to obtain information and documentation regarding Respondent 1's involvement with complainants. After an auditor visited Respondent 2's firm to obtain the relevant transaction files, Respondent 2 submitted a response approximately 1 month after legal counsel's original request, providing information regarding Respondent 1. Respondent 2 indicated that there had been a few clients who had raised issues with Respondent 1 over Respondent 1's period of affiliation with Respondent 2, and each time Respondent 2 met with Respondent 1 to resolve any issues, and Respondent 2 closely monitored Respondent 1's actions. Respondent 2 states that Respondent 2 was contacted by complainants and encouraged complainants to file the TREC complaint against Respondent 1. At that time, Respondent 2 returned complainants' earnest money for Home A, which had been dispersed to the seller, and deducted the amount from commissions due to Respondent 1, and broker released Respondent 1 from Respondent 2's firm. It appears that when Respondent 2 learned of any problems with complainants, Respondent 2 worked to resolve the problem and broker released Respondent 1. However, Respondent 2's response to the TREC complaint was submitted well outside the 10-day statutory requirement in Tennessee Code Annotated Section 6213, 313A2, and well past legal counsel's request for the same. Recommendation with regard to Respondent 1 is a consent order for $3,000 for using or promoting the use of any real estate listing agreement form, real estate sales contract form, or offer to purchase real estate form that fails to specify a definite termination date in violation of Tennessee Code Annotated Section 6213, 312B9, and for failing to diligently exercise reasonable skill and care in providing services to all parties to the transaction, and failing to be loyal to the interests of the client in violation of Tennessee Code Annotated Section 6213, 312B14, 6213-403 subsection 1, and 6213-404 subsection 2, plus attendance by Respondent 1 at one entire meeting of the Commission within 180 days of Respondent 1's execution of the consent order. With regard to Respondent 2, the recommendation is a consent order for $500 for failure to timely respond to a complaint filed with the Commission in violation of Tennessee Code Annotated Section 6213-312B14 and 6213-313A2, plus attendance by Respondent 2 at one entire meeting of the Commission within 180 days of Respondent 2's execution of the consent order.
Any questions of Ms. Crop?
Excellent report. I'm not ready to make a motion. It seems to me that when we consider this, that Respondent 2, we've had them before, that $500 is extremely light for his action, that they both need to go to a ethics class, and Respondent 2 needs to go to a contract writing class.
Or number one.
Number one, excuse me, number one.
Okay.
And now, if you'll consider that, I'll make that in the form of a motion. Now, the amount of money, it ought, off of Respondent 2, my opinion, ought to be more than $500. I'll let somebody else set that amount. Any recommendations? I don't have a second to my motion, so it dies then.
Well, I'll second your motion on Respondent 1.
And I might need a little more clarification with how many hours, just for the purposes of when I draft my order. You said some
And time.
education, if you could give me a number of hours.
Additional education of contract writing and ethics.
How many hours of each?
Well, ethics class is what, 4 hours?
4.
And a contract is how many?
Well, anywhere from 3 to 6 hours typically. Just
Three
depends
to
on the
what?
class.
6.
3 to 6 typically.
Well, make it 6.
Make it
Okay,
6.
6 hours of contract writing and 4 hours of ethics for
Yeah.
Respondent 1.
Within how many days?
Well, he's got to come here in 100, within,
180.
let's see, let's keep him busy. Let him do it all in the,
All within the 180-day period.
yeah. He don't
I'm
need to be-
sorry, it's just I
he
have to
doesn't-
have
he
it
doesn't
real
need to be
clear for
selling-
my
He or she
order.
doesn't need to be selling the real estate anyway. They need to be going to school.
180 days,
Yeah.
okay? That clarifies 1. Now, did you also say education for 2?
Yes.
And how many hours?
He or she needs to go to an ethics class.
4
4-hour
hours?
ethics class.
Within 180 days as well?
Yes.
Okay.
And
The
just to
money-
supplement that, I think that we need to include not only failure to respond, but failure to failure to properly supervise.
Okay.
I think supervision's in there.
What are they adding? Failure to what?
Supervise,
Supervise.
failure to supervise. I
Did
mean,
you-
is everybody happy with respondent
Is there
two,
gonna be a fine?
$500?
You got a $500.
I know, I mean, is
Well,
everybody?
is there gonna be a fine for the supervision?
Okay, put 500 onto that, then that makes it 1,000 then.
Okay, I like that one.
Okay, so just so I have this clear in my notes, $1,000 total for respondent two, 500 for failure to timely respond, and 500 for failure to supervise, plus 4 hours of ethics in addition to the meeting of the commission, all within 180 days.
Right,
Okay,
that's my motion.
Okay.
Got a second to it, I believe, didn't you?
Yeah, I second it.
Even to respond to.
I'll even take respondent two now that they fixed it down there.
You've heard the motion by Commissioner Alexander, and it's seconded by Commissioner DeShara. You want the motion repeated?
No.
No.
Any further discussion or comments? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Do you need
Mr.
one?
Chairman, request the option of addressing the audience.
Go right ahead, Commissioner
Again,
Flitcroft.
again. If you are a principal broker, talk to your affiliates, find out what they're doing. Carefully monitor them. This principal broker didn't do anything wrong except he didn't respond in time, and that's something you shouldn't do. But he's out $1,000 because he didn't do these things. If you're a principal broker, you got a responsibility. Not only a responsibility, you got legal liability, and it's going to cost you money. Thank you, Mr. Chairman.
Commissioner Flitcroft, you're welcome. Commissioner Flitcroft using the pronoun he, I mean, we don't know if it's a he or a she or who did it.
I'd be violating HUD, wouldn't I?
Yeah, we don't know who it is. We don't have clues to who any of these individuals are, where they're from or anything else.
that's why it's so confusing to summarize.
I know, but you do a wonderful job, Ms. Crop. Thank you for the job you do for this commission.
Did y'all pass that? Are we ready to, I'm sorry,
Yeah.
it was just confusing.
6, 7, and 8 next.
All right, 6, 7, and 8, 2012-025-821, 2012-025-822, 2012-025-823. Complainants are lessees and respondents are affiliated with a firm which represents. I'm sorry,
He's got to change.
I can restart that one. I'm sorry, I didn't see you.
Got to change the tape.
Thanks for flagging me down. I would have just kept going.
Oh.